So as you just heard, we are recording the session this evening, and we'll be recording all of the VirTuesdays, one each month through the month of October. I want to thank our presenters this evening for joining us, and Joe Schmies is here, the Executive Director of the Indiana Association of Soil and Water Conservation Districts. He will be facilitating tonight and introducing our speakers to us. So thank you again for joining us, and I'll turn it over to you, Joe.
Good evening, everyone. Thanks for being here tonight. Thanks to our speakers. We'll get started here. I think this topic is of interest to me. I get a lot of questions, year in, year out about insurance and liability, and then and in terms of liability, how that impacts the work that you all do as employees or as supervisors, and how your status, either as a county or state body, how that kind of plays into your liability. So the first speaker we have this evening is actually pre-recorded. Josh Croy is our association insurance agent. He works for the Indiana Farm Bureau Insurance, and Josh is on family vacation this week, so probably having much more fun than us, although I think we're going to have a lot of fun. So Josh's presentation, we kind of talked in advance about some of the things that I think that you all deal with, and about he's specifically addressing that a liability policy that the association holds on behalf of districts, and so a lot of that is focused towards that. So Josh did say any questions that come tonight, if I can't answer them, that he would gladly provide follow-up for questions. And then we also have a document that kind of gives an overview of our policy. And on that document, I'll put that in the chat here after the video starts, that actually has Josh's contact information as well. So you could either reach out to me or you can reach out directly to Josh, and that'd be fine. So with that, I'm going to share my screen here and play this video. Well, thanks for joining us. This insurance agent at Farm Bureau, Josh Croy. Josh is going to talk to us a little bit about today. I'll go ahead and turn it over to you, and go ahead and take it away.
Yeah. Thanks for having me. One thing I guess I want to start out with, note that this is a liability policy that the state has. It does list every county soil and water district on there. It lists your office locations, and it will cover your county events that you're having. Note that there are some exclusions that we'll go through, but note that it is a liability policy. If you guys have autos, you need to make sure that they're covered either through the county itself, or if you have an individual policy on those for physical damages and things of that nature. Also, if you have equipment, that's another one. We have a lot of soil and water counties that have policies that cover their equipment. So just note the difference there, that this is for liability purposes, not for necessarily physical damage coverage on equipment or autos and things of that nature. I know those are a couple things that come up. Things to know, I mean, if your office does move, please let us know so we can update, that location, and meaning there, if somebody were to come onto the property and get injured, let us know so we can get a claim filed. There could be some chances that, this policy could come into play there if their liability is warranted, but that can funnel through the claims and where that needs to lie. Also, we have some districts that have some ground that they own and control in different instances. Those have been allowed onto the policy as locations. Those, let me know. I work with Joe, and then we can figure out if that's something that should be on the policy or not. As far as activities go, if you guys are having an activity at a location, you're on it, you're having people out there, That's what this policy is for. It's covering the liability of having them out there if they were to be injured in some way, shape, or form through that. It's automatically there. You don't have to do anything for that. If the landowner or location is asking for a certificate, that's perfectly fine. Just reach out to me, let me know the name of the person or the location, and the address usually helps, so we can associate that with it. And then we can get you a certificate for that event to cover that. It doesn't cost anything. That's already included in the dues that you pay to the state that covers this policy. So it's fine to get that if you need it, but you certainly don't have to have it. It's already there and enforced. I know that part of this presentation will be covered on the auto side with tort. If you guys have an auto claim, let that funnel through tort. That's going to direct that to where it should land. More than likely, it probably won't be impacted on this policy, because again, this is a liability policy, but tort will control that, and they're going to determine where that falls.
Josh, just real quick,
yes.
and to clarify, the tort process is the government process that it goes through if it's covered by like county or state government, correct?
Correct. It's going to funnel through federal first and then state, and they're going to control and direct where that liability falls. So that's their role in this, and I guess more or less let us know so we can be prepared for if anything were to come. But first and foremost, it needs to be related to them and I guess more or less filed with them, so that they can start their process of figuring that out. And you'll hear more about that, I'm sure, from the Attorney General that's speaking. As far as exclusions, there are 5 exclusions that you'll see on the policy. Transporting people by you or on your behalf on water or streets or roads, we can't be on that. That doesn't mean we can't cover the event once the people are there, but we can't cover the transporting of the people. We can't cover overnight camping, use of firearms or archery, and use of chainsaws in the felling of trees, and hay rides involved with anyone under the age of 18 unless they're accompanied by a parent or a guardian. I guess a clarification I've ran into on this one a lot is water. We can cover up to the water's edge if you guys are having an event. Now, being on the water or in the water is something that you're going to need a special event policy for. That's something that I can get for you, but you're going to pay for that on your own, or another insurance company can arrange that for you as well. But just note that we can't cover you while you're on or in the water. We can cover up to the water, but after that, you're going to need an event policy that you take out on your own. So that's one that's came up a lot with river cleanups and things of that nature. So I wanted to point that out. When in doubt, you can always reach out to me. In the handout that you guys have all gotten, it has my contact information on there. I'm more than willing to answer any questions that you have, or find out the answer to any questions that you have, as well as issue those certificates. So it's a pretty straightforward process. I try to get those turned around as quickly as I can. I ask for as much lead time as you can give me, because if there is a chance that I'm out or on vacation, it gives me some time to get that back to you, so we're not up against the wall of having you have an event that needs that certificate and needing that turned around quickly. So as much lead time as you can give me on that, I appreciate it. But if you guys, in a lot of, I guess more or less teaming up of events has been going on, which is perfectly fine. And note that if the county soil and water is in that and it's not hitting those exclusions, we don't have a problem filing that certificate if needed. So that's, again, this is all included with the dues that you guys pay to the state. So it's nothing special that you need to take out or will cost you. Those certificates are free and they're all included in that. So anything that you guys are needing on that behalf, just reach out to me and let me know, and I can get those around for you. But again, if you have a claim or something comes up, let me know, and then I'll work with Joe and we'll find out the proper way of getting that filed or the next best step to go from there to help you. But the earlier you can let us all know, the better off we all are, because then we can determine where to point you or where to get that claim started at. Hopefully it doesn't happen, but things do come up. The only other thing that we've been asked a lot through the process of having this policy is the determination between employees and volunteers and how that all comes into play. When in doubt, let me know and let's get the claim filed, and then we can sort that out on the claims side of whether that should be covered or not covered as far as a volunteer or an employee or how that person's looked at, because the county will also be involved in that, and workers' comp could come into play as well. So it's going to be a bigger process. So when in doubt, just let me know and we can get that sorted out on the claims side. So I guess let me know any questions that you have regarding that or anything else that I've mentioned here. Joe, is there anything that you think I missed that you want me to go deeper detail about? It's kind of a brief synopsis and kind of a quick glance at the policy itself, but
yeah, Josh, I was just thinking while you were talking about on the auto liability, kind of the difference between owned and non-owned vehicles, and how that covers liability for like non-owned vehicles. And I know that this is something that comes up because we have a shared office with other partners, and so how does that liability cover or not cover us with like a partner vehicle or like an employee vehicle that's not owned by the district?
again, that's going to flow through tort. They're going to decide that, because you're going to have people that are using their personal vehicles to run up and down the road to maybe go get mail. Then your personal auto policy is also going to come into play with that. You could be jumping into a county vehicle to where the county policy is going to come into play with that, or even a federal vehicle for some of your guys' cases. So again, the best case scenario, you can come up with any kind of scenarios that could happen to. I'd say, let's get the claim started. Let's get it announced to the Attorney General and let it flow through the tort process. Again, they're going to determine where that liability should fall. And then the physical damage side will be handled by the policy that, is that auto is covered underneath, whether that be the county or whether that be, the individual district that has an auto, because some of them do. And some of them just have county vehicles or be your personal auto policy. But it will have to flow through that to determine where that liability falls. So it's all gonna, start there and more or less in there on their determination on where that should land. I guess hopefully that clarifies what you were asking there.
Yeah, and so if the liability comes back to, it goes through, let's say like the county and the personal, and there's not liability coverage there, then our policy is kind of like that backstop, right?
It's going to be kind of a backup policy to that, but again, they're going to determine where that falls. if they determine that it should fall on the soil and water, through that, then that's where the liability will go through. But again, they look at that, they determine that. Their determination is more or less, the finalization of where that is. So if they look at it and they determine that it should fall in the soil and water's hands, then that's where this policy would come into play at that point in time for the liability. So,
and so and I guess one last question to clarify too. So that liability would cover owned and non-owned vehicles. So it would cover like if for like a partner like NRCS, if we were driving an NRCS vehicle and the liability didn't fall under the federal tort and made it back to the soil and water district, even though we didn't own the vehicle, we would still be covered under the policy, correct?
well, there could be some liability coverage there. Yeah. Again, liability, you got to note that that's for other people and other items, not you or the vehicle that you're in. So note that physical damage and med pay should be on the policy that's covering the auto, whether that be by the county or by the individual. That's where that coverage should come into play.
Yeah, and that makes sense. I think I always try to. We talked about this before, that I always try to remind people that it's what you're liable for. It doesn't cover all those other things
Right.
necessarily, but it's what you're liable for in terms of damages.
Right.
So I want to take this and turn it in a little bit different direction. We didn't talk about this before, Josh, but I thought of it while you were talking. We've had recent instances where there's like a lawsuit against like a soil and water district and like their supervisors or their board. And I think that there's been some confusion because they'll come to us and say, hey, we have this insurance policy. Does that cover us? And so can you explain why that doesn't cover things like a lawsuit?
Yeah. And I guess that can be taken in a couple different ways, lawsuits.
Sure.
Liability, there could be a lawsuit there for liability purposes. If you had somebody out, to a field, and let's say there's something that you set up and they tripped and fell and they brought a lawsuit that way. This policy would come into play in that instance. Or if you were a soil and water employee was handling something, they hurt somebody that was out there for a reason, and lawsuits come along, this policy would jump in place for a reason like that. As far as now, this policy won't cover other forms of liability, like for instance professional liability. If you're out there and you tell a farmer that by doing no-till, it's going to increase your yields by X amount, and it doesn't, and they bring a lawsuit against you for that, that's professional liability. That this policy is a general liability. It wouldn't cover, things of that nature. So note that. Also, if there's a chance that a soil and water county could be named in a lawsuit by somebody getting hurt, and really it has no impact on the soil and water. They're just reaching and trying to put, as many people named on the lawsuit as possible. But there isn't a chance that you really have a liability, instance there. Still let us know so that we're prepared for that. But more than likely, there isn't a need or a reason that that should land on soil and water's doorstep for that reason. Trying to think of other reasons that a lawsuit could come up. I guess you did note the board things, and I know something has happened as far as hiring or firing or things of that nature. This is not a directors and officers policy. If a board, would like to look at that as protection for themselves, that's something that they would need to take out on their own to protect, their individual board members. If that's a worry to them, that's something that they can contact their individual county attorney and see if that's something that maybe that they should be looking at as far as coverage. And then if that is something that they're worried about or needing, that's a policy that they would need to, I guess, more or less individually go and purchase for that individual county or district to be covered in that instance. I know that's came up in the past, but again, you got to note that this is a general liability and it's more or less covering, liability to the offices, the locations and events that are going on, not for those other types of circumstances, such as, directors and officers or professional liability in that case. Does that answer your question on that?
Yeah, that's exactly what I was thinking. And to clarify for districts that are under the state law that kind of creates districts and discusses supervisors and employees, it actually does mention that they fall under tort, the tort process for things like that too. And we've actually worked with the Attorney General's office to get some kind of information on that, because I think there was a lot of question about, like the association, we are a nonprofit, so we have to have directors and officers and some professional liability in certain instances for some of our programs, because we're not covered by the government in that sense of like the tort process. But like in the code that establishes districts, it does say, that the tort process covers them. And when you kind of dig into that, it talks about how, that they're not personally liable per se in their day-to-day work as professionals and as supervisors. Obviously that doesn't cover if they've done something illegal,
Right.
But in their day-to-day work, they fall under kind of that tort law. So,
Right.
That's exactly where I was going with that. Thanks, Josh. I think we've covered everything. I want to, thank you, Josh, for being here. I think that you did a great job of kind of covering the basics of our policy and kind of probably thinking about for the districts what they need. It's interesting for us because each of our districts are a little bit different, and
Right.
that some of them staff are county employees, some of them they're not.
Right.
Majority fall under county, and then our supervisors aren't necessarily considered county employees, but they're established under the state. So I think it's helpful with the conversation that we've had about this policy. And I know Josh, you mentioned it, but folks can reach out to Josh, and we'll provide the PDF document here that has the kind of summary of the policy and Josh's contact information. If folks have questions about it, they can also reach out to me, and I can help funnel things to Josh as well if you have other questions. But again, Josh, thanks for being with us today. I appreciate your time, and I've appreciated working with you thus far. And
Same here.
Yeah, any questions that we have for Josh, we'll definitely funnel your way.
All right. Thank you.
You're all still here, I think, right? It's different doing a recording like that. I did see in the chat there was a question, and I think it said, what do we do in an emergency situation? Obviously, I think in an emergency, the first thing you do is if someone's in danger or anything like that, you call 911 and you handle the emergency situation first. But definitely, just like you would if you got in an accident or anything else, you would contact Josh as our insurance agent. You don't even have to go through Joe or the association, and let them know that that something happened, and then they'll get the process started right away. So if there is an emergency, obviously take care of the emergency, and then after you've handled and everybody is safe and the situation is somewhat handled, then you can contact your insurance agent. But and that would be Josh. So I'll pause for one more second. I don't know if there are any other questions right now. Again, I think Amy put in the chat there the PDF document that was referenced. And so you heard a lot. Josh said it multiple times. Tort, and it's not a delicious bakery item, although sometimes it can be. It is a process, and we've got Winston Lynn here with the Attorney General's office. I'm so glad you could be with us tonight, Winston. Get your title right here. Winston is the Assistant Section Chief for Government Litigation at the Attorney General's office. And so, Winston, I'll turn it over to you. We'll talk a little bit about tort, and then I think that'll help connect some of what Josh kind of referenced. And then, we'll kind of keep an eye on the chat for any questions.
Thanks, Joe. It's my pleasure to be here tonight. I have a summary that I'm prepared to give, but I also welcome questions. I think, the main point of me being here today is to help address practical questions for you to answer probably a thorny and somewhat scary concept called liability. And so, yeah, whenever you have questions, please let me know. I'll also take a break in the middle and at the end for questions. So just to sort of clarify things a little bit, I'm here to talk about legal liability. So it's a different concept than sort of like, where is the money coming from? So, assume for sake of argument that you hit somebody. So liability essentially is the other person is owed something, right, to make them whole. They were injured, the car was totaled, you might have suffered a shoulder fracture or something like that. So in order to compensate them, there has to be some sort of money. And that's kind of where insurance comes from. So like, I think the distinction between what was just said and what I'm going to talk about is that I'm talking about like whether you're legally liable for what's happened, and what's previously talked about was where's the money coming from. So there's just two different concepts. Both are very important, right? But I'm here to sort of clarify sort of like the first step, which is who is liable, if any, right, for this kind of incident. So two main goals for tonight. The first is to demystify torts for you a bit. Again, it's not just a delicious pastry. And two is to reassure you that you are protected under the Indiana Tort Claims Act. So you're not personally liable if you're acting in the scope of your employment. It's an important phrase. It's very fact intensive, so I cannot tell you exactly everything that you must do to be within the scope of your employment, but I'm happy to sort of explore the contours a little bit and sort of help you understand what that means. So just to talk about torts, generally speaking. So what is a tort? It's basically a civil wrongdoing that causes harm to a person or their property. So it's a very generic term. There's all kinds of, ancient torts, battery, assault, more recently, intentional infliction of emotional harm, that sort of thing. So it's kind of a generic term, but I think, the basic thrust of it is that you have done something to injure someone else, and they are essentially seeking recompense for their injury, either damages or some sort of injunctive relief. So a couple examples, right? Where there's an incorrect traffic sign, there's a lot of construction recently. The sign says, hey, there's a curb coming up to the left, but you know what? The curb actually is to the right. So it caused a huge accident, trucks piled up, that sort of thing. Someone most likely would sue INDOT, right? So in that situation, that is a tort because it's caused harm to the people who are involved in a traffic accident. A more direct example would be, so in Indiana State Trooper, they're chasing someone, there's a car chase, they're resisting arrest essentially. And that person, because of the way they've boxed him in, crashes into embankment and passes away. That's sort of like more of a wrongful death, but it's also a tort because essentially what they would argue is that you have forced them into a situation or caused them injury or death, right? Based on your actions as sort of a state actor of sorts. So those are two examples of torts, and I'm sure there are others. For you, I'm going to use an example, just sort of one that you might be more likely that you might be in, that sort of thing. So, imagine you're driving to an event where you're going to educate some students. You're before an intersection. In the past, you've never seen a car. You're in a hurry, you're late, and so you just, you floor it. And all of a sudden, a car comes upon you and hits you. So in that situation, what I would say is it's essentially negligent driving of sorts, right? You've done something, it's in the course of your employment because you're essentially going somewhere to teach students, which is part of your job profile. But on the way, you did a negligent action. You did not drive carefully. You did something that was against the traffic laws, and you caused someone else injury to their person or to their vehicle, or both. So in that situation, this is what I'm talking about in terms of the tort for the rest of the evening. That's the kind of situation I'm kind of envisioning. Also, I think it was previously mentioned, hey, what if you have an event and there's like a hole or something like that? You knew about it, but you didn't put like a warning sign or something like that, and someone fell. That's kind of also kind of example of a tort. It's more indirect. It's like a premises liability kind of thing almost, but it can also be construed as a tort. You didn't provide safe surroundings for the attendees. So that could also be construed as a tort. Yeah, so I'll stop there for a moment. Does anyone have any questions? All right. So what I've talked about mostly right now are state torts. So there's also federal torts. And I'm going to talk mostly about state torts for the evening. You're more likely to encounter them. Federal torts, it's essentially a species of 1983 action. I know that's just legal jargon for you. It doesn't make any sense. It's essentially a federal statute that says if a state actor violates the constitutional right of somebody, there's essentially a federal right of action against that person or the entity behind them. You probably won't see it. From my understanding of what you guys do, you likely won't encounter it because it's just not one of those situations where you would violate someone's constitutional rights. It's unlikely. So I'll leave that aside, but just be aware that federal torts are different. There's potentially personal liability there, but the fact pattern for that to happen is unlikely, and I cannot sort of speculate to that right now. But what I can tell you about are state torts, which is the subject of a state statute that Joe just talked about previously. So there's an Indiana law that says supervisors and employees of the districts are protected by the Indiana Tort Claims Act. So this is a statutory regime. It's in the Indiana Code. It's set up mostly for state employees. That's where its designate purpose. To be specific and just to clarify, so employees of the districts are county employees. So you're paid by the county. This is also statutory. They pay you and you're under their HR policies or whatever you want to call it. So ordinarily, you would not be under the Tort Claims Act, but this law essentially says, we'll ignore that for purposes of liability. And you are essentially protected by the Tort Claims Act. So what is the Tort Claims Act? It's very confusing to a lot of people, but what it is in essence is it provides immunities and essentially procedural processes for the state employees. So the point of it is that, hey, state employees, we want you to do your job without worry that you're going to be personally liable for all these things that you do. Because if you had to be worried and you had to be concerned every time you did something, no one would get anything done. So the whole entire point of it is to provide essentially immunity to personal liability if you're within the scope of your employment. Again, that's sort of the critical phrase. And then just sort of, if there is an incident, right? It's not, even if you're not personally liable, someone is going to be liable. And by someone I can also mean, the district or the board or someone else, right? So even if you're not personally liable, they can still file a lawsuit or try to claim some damages, and there's a process for them to go through. So the process, I'm just going to lay out briefly. You probably won't necessarily encounter this, but the process essentially is that, based on the question earlier, what if something happens at an event, emergency? I echo the sentiment. It's not exactly legal advice, but just, obviously make sure everyone's as safe as possible, do whatever emergency care or procedures are appropriate, and then you can worry about liability. So if someone's injured, they have 180 days to provide notice to the board, also another state entity. So the notice was essentially, I was injured on this date. This is what happened to me. I claim X in damages. So the government then has 90 days to approve or deny that claim. And if it's not approved within that 90 days, the person can file a lawsuit. And then, so the lawsuit is essentially a real piece of litigation. It's most likely going to be filed in state court. As I said, most of these are going to be state claims. The caption will read something like John Doe versus, you might be listed, and then the district, your supervisor, the board, the state of Indiana. So they name a whole host of people to capture as many people as possible, just in case they missed out on someone. Don't worry about it. If you're within the scope of your employment, the person representing you will try to dismiss you and will most likely succeed. So again, let me reassure you that if you're within the scope of your employment, most likely you will not be personally liable for whatever incident it is. There are exceptions, of course, right? So, the phrase within the scope of your employment. So if what you're doing is criminal, it's malicious, it's willful and wanton, or you did something like embezzled funds, right? So for your own personal benefit, you did something bad. you're not going to be protected by the statute because somewhat obviously there's a bit of bad intent there, and so it's not within the scope of your employment. It's going to be one of those things where you're not going to be protected and you may be personally liable for state claims. You may have a question, okay, so what if I'm driving a state vehicle and I'm picking up my kid, but dropping them off, and then while heading to teach students, right? So these are all the fact patterns that state troopers encounter all the time, and it's fact intensive, and I cannot tell you sort of a black and white kind of line there, but essentially the more that you're following the line of doing your job duties, the more likely that you'll be in the scope of your employment. The more that, say, like, okay, you work the morning, you're like taking off a couple hours to take your kid to some sort of doctor's appointment. On the way there to the doctor's appointment, then it looks less likely that you're within the scope of your employment. And then that sort of situation, that'd be more up to you, right? Like your personal insurance would cover that or not. But the more that you're within the scope of your employment, the more that there will be you won't be personally liable for the incident. So that was really a quick sort of summary of what happened. I'm really happy to answer questions. I just want to make sure like what I'm saying is useful to you and that actually addresses your concerns. Also, Joe, if you want to jump in and ask any questions too.
Yeah, and just a reminder that you can put questions in the chat box for Winston if you have any while he's speaking here.
So Winston, I think I know one example that I think someone's dealt with is like wrongful termination lawsuit, and so how would that kind of go through a tort process if there's if they're saying well, I was wrongfully terminated, how does that start and maybe like a tort process?
Yeah, it's a great question. So this causes a little bit of complication. So an employment decision is not a tort. So it basically falls outside of the whole entire apparatus of tort litigation. So we handle, so the Office of the Attorney General does handle employment cases. It may shock someone, but people get fired all the time in state government. They also get hired all the time. So great. It's not tort because you're not actually doing harm to the person of some sort of physical nature or based on some sort of incident, right? It's honestly more of a contractual matter. It leans more toward that. So the types of cases that we see often are some sort of, hey, you discriminate against me, you terminated me because I belong to a particular class, and you fired me not because I'm an at-will employee, which is the norm in Indiana, right? So at-will means that you can be hired or terminated for any reason. Both sides can essentially do that. Like it's kind of a double-sided sword. So you didn't fire me legitimately. You fired me for a improper reason, which is that I'm in a protected class, and I was fired for that reason. So what we often see Title VII, so that's kind of the federal law that deals with this. You might read about it, but just sexual orientation, for example, is kind of been a big hot topic recently. That's been affirmed by Supreme Court. So it's one of those things where more likely than not, it'll be a Title VII action, which is a federal case, which is a federal action. So you might see in federal court, or you might run into one of the few state cases where essentially the person is saying, hey, you didn't give me enough, like you just let me go, you didn't give me a hearing, I should have gone to hearing or some sort of like due process. And that can have sort of a state analog. So that's a lot of ways to explain it, but essentially that's not a tort. So it's not one of those things. So I'm assuming the supervisors, right, employees or whatever, that's not a situation in which the Tort Claims Act or the statute that I talked about would apply. So you're essentially outside of the whole entire torts process, and it would be handled essentially as a separate kind of employment law matter.
Oh, that's helpful. not seeing any other questions right now. Well, Winston, I thank you for being here. Oh, here we go. We've got one. I said it had to. What about? Okay, so question comes out. So I think this asks about what about non-county paid employees. So, so for example, like our districts, we have. I'm going to tell you what I think, Winston, and you can tell me whether I'm thinking in the right way. So we have some districts where their employees are not considered county employees. So we kind of have this, and they are typically they're funded some way other than the county, but they're still under the supervision of the district board. I think that they still would fall under the tort process based on our individual code, because our individual code says that soil and water supervisors and employees, it doesn't distinguish between government employees. Would they still be covered under this process because they're employed by the board?
The short answer, in my best opinion, is yes. So I think you're thinking the right way, the right legal way. Is that, so there's a statute that says the supervisors may employ necessary personnel, essentially employees, right? And there's like the statute also says, hey, if you're paid by the county, you're essentially a county employee, and you're subject to the county's policies and procedures. If you're not paid by the county, so the situation you're talking about, you're not a county employee. It's just a basic kind of thing of employment law where an important but not necessarily critical factor is who pays you, right? So if you're paid by county, you're a county employee. If you're not paid by the county, you're not a county employee. That's all the statute is saying. But the critical part is what you're saying. Essentially, you're still an employee. That's all that matters. So no matter who pays you, as long as the supervisor hired you as a necessary personnel, you are an employee, and you'll be protected by the Indiana Tort Claims Act.
Okay.
I don't think this applies to volunteers, if that's sort of a follow-up question.
Yeah.
I can't say that volunteers are employees because, definitionally they are not, paid or enjoy any sort of the employee protections. So they would not be covered by the Tort Claims Act.
That makes sense. Okay. I'm waiting one more second here to see that. That was a good question.
Yeah. It was.
Well, Winston, I appreciate you being here tonight. We'll go ahead. We'll transition to our last speaker here. And if anything comes up, we might have another question that comes up here, and after we talk with Roger. So Roger comes at this from the federal side a little bit here. He's with U.S. Department of Agriculture's Natural Resources Conservation Service, NRCS. Roger is our State Assistant Conservationist of Management and Strategy. See, I think I got that right, Roger. And I've had the pleasure of working with Roger on things like our partnership agreements, and then one of the ones that's somewhat newer, well, not newer, but we've talked more recently about too, is vehicle policies and vehicle sharing. So Roger, I'll turn it over to you, and you can tell us a little bit about that side of things.
Yeah, thanks, Joe, and also thanks Geneva and Amy too for having me. I appreciate you asking and letting me do this. So hopefully it'll be beneficial. And I know we want to talk about some of the insurance side of things, but let me just cover some general big bucket items with vehicle use in general. There's be a lot of acronyms I'll use. GOV is a government-owned vehicle. So that's when I say GOV, that's what I mean. Things, MOU, obviously Memorandum of Understanding. But let me just start with that as kind of the big bucket tool that we use as one of our foundational documents to be able to share things within our partnership. So we have the Indiana Conservation Partnership MOU that was signed in January of 2019 by all 92 districts. And then that document runs until December 31st of 2024. So we still have a few more years on that document, and that just kind of lays the foundation of how we operate together, what we do and don't do, and what each partner is responsible for. And so there are some other documents that as a partnership we can put in place. that may not involve all of our partners. It could be a document that just needs to be between the State Department of Agriculture and a local soil and water conservation district. And those supplemental MOUs outline in further detail how we use space, equipment, vehicles, personnel. And so I know the partnership is still interested in getting some of these further supplemental MOUs in place. And those are pretty solid national templates that all of the national partners had input in creating. So there isn't a lot of wiggle room in those documents, but we're all interested in getting those in place as well. Kind of the use of the federal GOVs, just some of the big bucket items. I have a list of 21 do's and don'ts. I'm not going to read them all, but just some of the big things that our partners need to be aware of when they're utilizing a federal GOV. Think of just following the common sense Indiana state laws. You need to have an Indiana valid operator's license. You have to use all the safety devices, so make sure you're wearing your seat belts. Don't turn off any airbags, anything like that. There's no smoking in federal GOVs, and you have to follow the Indiana law on the use of mobile devices. So even if you're crossing state lines, if Illinois' laws are different than Indiana's laws, you have to follow Illinois' laws while you are in Illinois. That's just the way it is, how we operate. That's what the policy says. It was interesting in 2019, Geneva and her group at the Indiana State Department of Ag did a survey of all 92 districts. And the responses were that I think it was around 15 to 17 SWCDs routinely or occasionally used a federal NRCS vehicle. So it wasn't as widely used as what I had anticipated from years ago. But there's still some of the use going on out there, which is fine. The vehicle use policy is in place for the vehicles to be shared. So we just want to make sure it's done correctly. Also, for a partner to utilize one of the federal vehicles, they have to take the federal fleet card training, and then that gives them access to a fleet card PIN number, which they can use to gas the vehicles if they need to have repairs done, which we would take care of that 99% of the time. That's why we use the federal fleet card, but you have to take that training in order to operate a federal vehicle. So that's all done through our AgLearn system. Kelly Bays on my staff can walk any of the partners through the process to obtain one of those. It's not very difficult, just one of those hoops that you need to jump through and make sure that you've done everything correctly and everything's in place. Also, something new that's come into place the last couple of years is our vehicle management tool. So you'll hear the acronym VMT a lot, and that's just our new online reservation system. When the previous administration, the Trump administration, came into office, they realigned some of our agencies within USDA, and they created a mission area called FPAC, Farm Production and Conservation. And so the FPAC Business Center is the one that created the VMT. And now, not only are NRCS vehicles used by NRCS and our partners, but they are used by other federal agencies. So the Farm Service Agency, our CEC IT group, Risk Management Agency. So we have a lot of other people utilizing our own NRCS vehicles. So the use pressure has increased on our fleet significantly over the last 2 years. So just keep that in mind, that use pressure has increased. If a partner needs a vehicle certain day, they just need to make sure to reserve it through the vehicle management tool and make sure one is available. That's something we don't do. We do not guarantee that a vehicle will be available when someone needs it. It's just strictly through that reservation system. And if the vehicle isn't reserved and it's available that day, then it's fine. You can go ahead and make your reservation and take it. But that's something new that's come across the last couple of years. A couple other big bucket items as far as do's and don'ts. NRCS will assume all responsibility for maintenance and care of the vehicles. So if it needs new tires, absolutely, we're going to buy new tires. If it needs new brakes, we'll make sure the vehicle has brakes. So it doesn't matter whether RMA's been using the vehicle, FSA's been using the vehicle, or NRCS has been using the vehicle. We're going to take care of that maintenance and make sure the vehicle is safe for use. And that involves oil changes as well, routine maintenance. Something that is prohibited by partners are taking vehicles home. Not allowed to do that. Federal employees can do that in NRCS rarely or occasionally, we say, as long as it is benefiting the government. We allow employees to do that, but they have to have the proper forms in place. All has to be signed all the way through up. I'm the final approver for those for Indiana NRCS. And so, but the policy does say that our partners do not have that option to store vehicles overnight at their house for any events that may be going on or places they need to go to the next day or they're coming home from that day. So as I mentioned before, furnishing of vehicles is contingent upon availability. So we don't guarantee there's going to be one available. And then the last two kind of big bucket items I want to cover, and Joe, and I know that's your intent for having me, are accidents. So in late 2018 or early 2019, our Office of General Counsel, who we call OGC, that's the acronym, that's the USDA's lawyers, they ruled that that our partners are not covered for property damage and liability under our tort claim process. So that was kind of a shift, operational shift that as an agency we didn't see coming, but it did impact a lot of our partners tremendously. So with that, if a partner is operating a vehicle and something happens, anything from being in a bad accident that they're responsible for to just, oh, a deer ran out in front of me and I hit someone's mailbox. The partner is responsible for the liability that is caused to the other people, and they're liable for the property damage that may be caused to the federal GOV. So that was a new twist back in late 2018 or 2019. And so it really is important for the partner to ensure that they're covered for that if they're utilizing the vehicle. We just want everybody to know that up front, that was a change from then. And I think as a partnership, we've talked about this the last couple of years. I don't think that's a surprise tonight to anyone that happened. So just keep that in mind. So how the bullet item reads, I'll read this. The partner will immediately report all vehicle accidents and traffic violations to NRCS and complete all required documents to report accidents. The partner will reimburse NRCS or pay the auto repair company directly for any and all repairs to the vehicle as a result of an accident caused by the partner operator and pay all traffic violations, citations. And the partner will assume all responsibility for claims arising from the accidents caused by the partner drivers. So that could be where if you hit somebody and it was the partner's fault, there could be other liabilities involved through those other individuals that were hit. So Joe, I think that's the main information that I wanted to run through. If you had any other questions that you have, or I'll take other questions that anybody else may have. I'm not an insurance expert, don't claim to be, but we'll do our best.
Thanks, Roger. No, I think that was great. I think probably, what I think about, we've talked about our policy from the association covers liability, but not collision. We did, when NRCS, I guess I should clarify this, when NRCS changed their policy there at the national level, we did talk to like our insurance agent and Farm Bureau Insurance about, what would it be like to try to cover insurance like that, just in terms of a price or logistics to cover districts for that kind of collision coverage. And basically it becomes not very realistic because the collision insurance base is based on the vehicle driven, the driver themselves.
Right.
Those types of rates are different than like the liability rates that they have for general commercial liability. So it wasn't really feasible for the association to even really take that on. So our recommendation was, if the NRCS vehicle is needed on a regular basis, that the district seek out an individual policy for those folks.
And Joe, I've had discussions over the last 3 or 4 months with 2 SWCDs who are pursuing this, and it's difficult. It really is for local insurance companies to put it all together, because there's so many different moving parts. Because a county may have access to 2 or 3 different government vehicles, and they could range in age of 10 years. So how much insurance do you need for, you may be covering too much for a 10-year-old vehicle that one day you might get into a vehicle that's a 2020.
Yeah.
That needs different insurance than what, a 2010 is going to need. So there are some challenges that are real.
So I'm going to ask you a hard question. And you can just say you don't know if you don't know. Is this, I guess, what is the permanence of this policy? Is this like at the USDA level, or is it across all federal government?
The ruling that we got was from USDA's Office of General Counsel. So it was the suite of lawyers that service USDA as a department. And that is a group that I work with directly out of Kansas City.
Okay. No, that's helpful. Well, I don't see any questions in the chat, Roger. I think you covered that really well. We appreciate you being here again. Thanks to Roger, thanks to Winston, and thanks to Josh and Spirit. I'll turn it back over to Amy to close us out here.
Yeah, I just want to thank everyone for joining us this evening, especially our presenters. Am I echoing? It's echoing on my end. Anyway, thanks so much for joining us this evening, taking time out of your evening to join us and share the information you have for districts. Very beneficial. I'm excited that it's recorded, and it will be posted on the IASWCD.org website. And just a reminder to those who are on here, we can also you can still register for the upcoming VirTuesdays, August 24th, September 21, and October 19. So you need to register to receive the Zoom link, and we hope you will join us for those. And once again, thank you, Winston, and thank you, Roger. We appreciate you being here, and have a nice evening, everyone.
Thank you.
Thank you, everybody.